The present situation represents, in my view, a disproportionate reaction, and a disproportionate reaction eating particularly civilians.
Hello and welcome to the Justice Edit from Irish Rule of Law International. I'm your host, Evelyn McClafferty. On this show, we speak to the president of the International Bar Association, Claudio Visco, who talks about Israel's actions in Palestine since the Hamas attack of October 7th, 2023.
We clearly stressed that we expected proportionality in the reaction. If you ask me, as that proportionality occurred, and this is my personal view, it's Claudio Visco speaking, not the IBA, but I'm personally convinced that it did not.
Claudio also breaks down the legal justifications advanced for strikes involving the US, Israel and Iran, citing the UN Charter, questioning the nature of immediate threats.
Whether what Iran was doing was an immediate threat or not, there was never a clear indication that they were intending to use the weapons they were developing against those states which have been attacking them.
Claudio also expresses deep concerns over US sanctions on the International Criminal Court and executive actions targeting major law firms connected to investigations involving Donald Trump. He warns that while US democracy is under attack, he believes the system is fighting back.
And this is for us an indication that the rule of law is so much part of the culture of a country like the United States that we know that democracy will be able to regain the position that it should have.
Claudio also speaks about Russia's actions in Ukraine. The International Bar Association has been deeply involved in supporting accountability efforts around Russia's invasion, including work around a proposed special tribunal for the crime of aggression. But why is a special tribunal considered necessary in the first place? What can it do that the International Criminal Court can't? Claudio starts our conversation with exactly that.
It's quite a complicated situation, but if we want to try to summarize and make it simple, is that the jurisdiction of the ICC does not extend in principle to the crime of aggression. There are other crimes as genocide, etc., but the crime of aggression is not contemplated, and there were several attempts in the past years to include that crime within jurisdiction of the ICC, but none of them was successful. There is only one case in which the ICC may have jurisdiction on the crime of aggression, which is the case in which it is the Security Council of the United Nations asked the ICC to take jurisdiction, which, as you can imagine, due to the veto right system, it will never happen in the present situation. So we do appreciate, and the ICC itself appreciate, that is not particularly effective and straightforward to have a separate tribunal for this type of crime. But between the two alternatives, having nothing because they cannot take the case, or having a tribunal, at least up and until an agreement is reached, there is a new round of negotiation between the state parties. But unfortunately, this is going to be completed in 2029, and we really hope that by 2029 we would not need any longer that. So if this is a meaning, it is meaning now, even possibly as a mean of pressure to come to peace, which is of course our ultimate goal. The fact that there might be a tribunal, and therefore that the troika, as we used to say, may fear being exposed to that, it's really one of the goals that we want to achieve through the tribunal. We are quite conscious of the fact that probably any treaty that will be entered if an agreement is reached between Russia and Ukraine will probably have immunity as one of the first point of the list. But still, we are working as if nothing of that will happen, and we believe that the response we have been receiving is extremely good.
One criticism often levelled at international justice, Claudio, is that it can often appear selective or geopolitically uneven. How important is it that this special tribunal on Ukraine is seen as universal justice rather than Western justice?
It is very important for us, and it's one of our goals at the moment in this initial phase of creating consensus, not to limit that to the European member state. We have already secured support from Australia, from Chile, and probably Costa Rica. So we are, of course, making a lot of efforts for creating this consensus. What we do is we try to engage with the local bar association and law society. We are offering them to come and to organize, it could be either a webinar or an in-person meetings. I'm working with one of the university in Rome to do that in person. The Law Society of Australia did it both in person and webinar, and we gather a lot of people from Ukraine, people from the legal community at large, and we really try to present and to create consensus at political level for other countries outside the European Union to join.
Looking beyond Ukraine, Claudio, the war in Gaza has generated an enormous international debate. The human rights wing of the International Bar Association has condemned deliberate starvation in Gaza as a breach of international law. Do you feel like the international legal community has responded to Gaza with the same degree of urgency and clarity as it has to Ukraine?
I think that probably not. We have to understand the reasons for that. I would say Ukraine was, at least at the beginning, and this is probably the real difference. Ukraine was quite straightforward. There was one country which has been attacked and partially occupied by another country, and that was a clear violation of the principle of international law. In the case of Palestine and Israel, at the beginning, there was an aggression which, in a way, justified a reaction of Israel. In our statement, which we issued immediately after the events, we clearly stressed that we expected proportionality in the reaction. If you ask me, as that proportionality occurred, and this is my personal view, it's Claudio Visco speaking, not the IBA, but I'm personally convinced that it did not. So the present situation represents, in my view, a disproportionate reaction, and a disproportionate reaction eating particularly civilians, which is another reason to really raise the hand and say, no, that doesn't work. We are trying what we do as the IBA, but as you can imagine, it's not an easy situation. But we certainly keep an eye on that. You mentioned that our HRI Institute has already been speaking on that. Just maybe as a matter of background, the Human Rights Institute, it's something we have created now, maybe almost 20 years ago, just to have the possibility of taking positions which are not regarded an official approved position of the association, because this would require, according to our constitution, to get consensus of all the constituencies, and sometimes you know that there are different views and different positions. So the fact that we spoke through the HRI is because the HRI, I think, is more free to take positions which are simply based on the interpretation of the basic principles, the rule of law, and really not be concerned about having to create consensus. People who are in our HRI are pretty qualified persons, and if they take a position, that is certainly a position which is in line with the general objectives of the IBA. We don't take it as the IBA itself, because that would require a process, but we clearly take it through the HRI.
You know, you say probably not in relation to the international legal community's response to Gaza, but do you worry that perceptions of inconsistency on Gaza risk weakening support for international justice mechanisms more broadly?
Yeah, the risk is there. The fact that you raised the point, it means that there is a perception that we may be seen to using different meters to different situations. However, we have to live with that. I think that Gaza is one, but an important point. But we are doing so many things on the human rights and the legal order, international criminal law, that we believe that the Gaza situation, of course, will not play in a beneficial way to us, but I don't think that it could get to the point of undermining our commitment and the outside perceptions.
Yes, but Claudio, but does the same rule of law language apply when the alleged violator is powerful, strategically important, or politically useful?
Well, you know the answer to that question. The same rule of law applied, no question. I was last week in Salzburg at the Salzburg Global Institute for a program, 4 days, to young lawyers, teaching them what the rule of law means, what are the implications, what the role of that corporates should play in securing that rule of law is applied. And one of the points we discussed and which was raised, this was exactly the one you raised, whether or not there is one rule of law applying in all situations. For us, in principle, there is one rule of law. As a practical matter, for a number of external factors, the way the rule of law is applied and is perceived might be different.
The International Bar Association has raised concerns over US sanctions on the International Criminal Court and executive actions targeting major law firms connected to investigations involving Donald Trump. When executive power targets lawyers, judges, and legal institutions themselves, are we now talking about a significant rule of law crisis within democracies themselves?
This is another point we have been discussing, because if you look at the perception that young generation may have about rule of law, it's probably different from the one with white hairs may have, having really being in situation in which the rule of law was really at jeopardy, and having lived that. But this is only a preamble. The answer is yes, it's a crisis of democracy, and no doubt the fact that the person who is just behaving this way, is getting support from almost half of the country. It's certainly very, very concerning. On the other hand, when I talk about rule of law, rule of law for me is also the ability of a country to object to what is happening. And even if for the executive orders, there is a significant part of the US public opinion which has been either supporting or neutral, not seeing that particularly risky for the democracy, there is another part of the institutions which have been taking position. The fact that federal courts have been really striking down some of these orders, that they have not stepped back, even knowing that they would be facing political pressures, is an indication that democracy is there. The democracy is under attack, but the democracy is reacting. And this is for us an indication that the rule of law is so much part of the culture of a country like the United States that we know that democracy will be able to regain the position that it should have.
The International Bar Association has previously raised concerns over US actions in Venezuela. More recently, legal justifications advanced for strikes in Iran involving Israel have also been heavily contested. From your perspective, where is the legal line between self-defense and unlawful preventative force? Are we now in an era where enforcement largely depends on power rather than principle?
This is not an easy line to be drawn. Maybe we can just look at practical example. In our view, in my view, and Venezuela is a case in which that was not a justified reaction according to the Article 2.4 of the United Nations Chart. That is sort of black and white. Then when we issued our statement, we got different reactions, one way or the other. Somebody, particularly from the European standpoint, said, well, you have been a little bit too soft, because in our statement we said at the beginning, we are fully aware of what this guy has been doing and the violations of the rule of law for which he's guilty. But at the same time, there are international law principles which cannot be disregarded, no matter what is the justification. We would be creating otherwise a precedent that we cannot afford to create. If you look at Iran, US, Israel, I think that the bottom line is that the borderline is not so defined as it was in the Venezuela situations, but still the international principle, you may like them or not. The United Nations Chart says that must be a reaction to an immediate threat of life or security. Whether what Iran was doing was an immediate threat or not, there was never a clear indication that they were intending to use the weapons they were developing against those states which have been attacking them. So, for me, this is a sort of gray area. I mentioned Ukraine. Ukraine, for me, is black and white in the other sense. Ukraine would justify a reaction because that is a clear violation, which was not justified by any action taken by Ukraine against Russia.
But do you worry that we are now in an era where international law still exists rhetorically, but is enforced selectively?
I think that we like to think that international law and public order exist. I wouldn't say that it's applied selectively. I would simply say that there are a little bit too many people who believe that they could find a justification for violating those principles. So the principles are there. In a way, in general terms, they have not been contested. But I think that there were too many situations in which the prerequisite for exercising the force as a reaction have been really justified in a very weak way.
Claudio, shifting gears a little and looking at the IBA, the International Bar Association's new rule of law literacy project with young people in Denmark, do you feel that younger generations are inheriting a more fragile democratic environment than their parents? Why did you feel that this project was necessary now?
Well, we felt that the project was necessary now because uh, I think we touched that briefly even before. The young generation lived in a period in which, with a few notable exceptions, the rule of law was constantly applied. And whenever it was violated, there was a sort of common reaction of the civil society worldwide. Uh, for us, that means that they do not have the exact perception of what could happen if the trends of violating the rule of law would continue the way it's doing now. Uh, I think that it would be important for the young generation to go through that sort of exercise, and again at the training program we had last week. This was one of the takeaway I got from participating and organizing that event. The takeaway is that the young generation at the moment have a very pessimistic perception of what is happening, uh, which for me it's not justified. As I said before, there are a lot of mature democracy, even those jurisdictions in which this violation are taking place, as I said, they still have a solid democratic structure and are capable of reacting. My feeling in talking with these young people in this other program was that they said, well, no, this nothing working, and state are not doing, company could more and they are not doing. So we want to try to take a sort of balanced approach and say, yes, we are the first one to work on what is going on, and what is going on as a number of serious attack against the rule of law. But at the same time, you should be aware that the society is reacting. So this is the message we want to convey. So you see certain things in a TV or you read it on the web. Uh, be reassured that the rule of law is there, that there are a lot of parties committed, and that there will be a reaction.
The project with young people in Denmark, Claudio, is grounded in civic education, but as rights and freedoms increasingly become shaped by algorithms and AI, do you feel that an understanding of the rule of law now increasingly requires a degree of understanding of technological power?
Absolutely, absolutely. And this is the reason why last week we have announced the creation of the IBA AI Institute, something similar to the Human Rights Institute we discussed before. Why an institute? An institute because we fully share what you have just said. The social impact, not necessarily the impact on the legal profession. We know pretty well now what the impact on the legal profession could be. We have been working for more than 3 or 4 years on these issues. At our last conference in Toronto, we had some 26, 27 sessions organized by our committee dealing with artificial intelligence. So we know the impact on substantive law. We know the impact on the legal profession, the organization of the legal profession, the organization of law firms. We know pretty well what could be and the risk we have from a deontological, ethical perspective. But what we do not have is a clear assessment, first an understanding, because we are all lawyers, and our understanding of the mechanism on which AI is working is certainly not adequate. So the idea is that through this institute, we will, in the first place, understand better, and in the second place, try to monitor what are risks not only for the legal profession, but for the civil society at large, and have the possibility to speak up as soon as we perceive that the risk of such an impact on the civil society and rule of law is one of the areas in which we are, of course, concentrating our attention could happen. So we are very committed to this new project. We call it Institute because we know that this is not a presidential task force or something that normally lasts the term of office of a president. This is something I want personally to leave to the association, a tool which will allow the IBA to be part of the international debate, interact with United Nations, OECD, European Union, and more importantly, the business player in this field, Meta, Google. We are talking with them already, and they do have their internal system and mechanism. So none of this big organization is unaware of the risk that their activities may present, and they, of course, they have internal functions which are dedicated to assess this risk and the reaction that the company is taking. Of course, you never know how much what the guidance and the messages these people will give to the business side of the organization is it's really taken into consideration or not. That's why we believe that at the higher level we could really play a role to make sure that we have responsible governance, which is the real goal that I think we are all expecting to be pursued by an organization like our organization.
There's growing evidence to suggest that some of the major AI companies are undermining and resisting regulation. You know, we've deployed this technology transnationally, but you seem to be saying that there is, an absence of shared standards, guardrails, and governance mandates.
Absolutely. That is exactly the situation. And when we were discussing this issue now it's maybe 1 year ago with the chief scientist of Meta. He told us something which was quite frightening. He said, well, at the moment, there are 25, 30 people in the world who are really governing the AI, let's call it market. It's a little bit too narrow, but it gives the idea. And so far, there has been a relatively good level of consensus about guardrails and things that could be done and things which could not be done. That was sort of self-generated force. But he said, if one of these 25, 30 people decide to go his own way, even though there is not consensus about the other 24, we will not have any tool to stop him. And that was extremely concerning. And this is why we believe that we should be creating at international level mechanisms which are really capable of making sure that if somebody takes the wrong way, the other who do not believe the same way will have the tool and will have the ability to stop him.
Claudio, as we near the end of the interview, I wanted to ask you briefly about the IBA's major impact study, looking into the relationship between the legal profession and civil society. One finding that stood out for me was that countries with stronger rule of law protections experience greater socioeconomic benefits from lawyers and legal institutions. What were some of the findings that surprised you most?
What is somehow surprising is the perception, because this is also important, the perception of the public opinion in certain specific areas. I'm making a couple of examples. One is education. In the field of education, 70% of the legal profession and 60% of the general public perceive lawyers' role furthering education as having a positive impact. So for education, lawyers have a role, and this role is recognized. If you look at other areas, for instance, environment, in which you would expect the role of lawyers to be perceived as very important and capable of improving the situation, you get a completely different scenario, because apparently 50% of the general public and 40% of the legal profession do not see a link at all between the legal profession and environmental sustainability, which is for me quite surprising. And something similar happens also with respect of the health and well-being, the contribution of a rule of law to health and well-being. Also, in this case, only 37% of the legal profession see a positive effect that the legal profession can have on this area, and 30% see that impact even negative. These are, in terms of reaction, what struck me more of the results of this study.
You know, Claudio, you're talking about the subsections there because overarchingly, the study revealed that only 54% of the public believe lawyers have a positive economic and social impact, compared with a 78% positive perception among legal professionals themselves. Do you feel that the public increasingly see lawyers as defenders of justice or servants of power?
Certainly, they do have a role whenever they pursue certain type of activities. Access to justice. Lawyers have a very important role in the field of access to justice, not only in terms of pro bono work, but also in terms of educating their clients, which could be corporate clients, or in the case of in-house lawyer, the very same corporation for which way they are working, to understand that access to justice and pro bono work should be not something which is an option for a big corporate, but it's really something which would be required to be complied with as many other obligations they are in terms of positive law provisions. And in discussion we have with particularly with the House councils, I have the feeling that they are fully aware of this role that corporate actors should be playing in this field, and this is the one on which we as lawyer can have an influence. Certainly, we cannot, or we can, but only to a limited extent, have an influence at political level. So the access to justice is a primary obligation of the governmental authorities. We cannot pretend to substitute ourselves in that role, and what we can do as lawyers is very, very limited. But if we look at what we do with our clients, I think that our role is increasingly positive and as a real impact.
And on that note, thank you very much for joining us, Claudio. It was great to have you on the programme.
You are welcome.
And that was Claudio Visco, the president of the International Bar Association. That's it for this episode. We're taking a break over the summer, but if you want to keep up to date with Irish Rule of Law International's activities, you can check out our social platforms. Thanks as always to our funders, Irish Aid, and to you, our listeners. Until the autumn, take good care.